knowledge update channel. In this video, I am going to discuss about one of the very important amendment of Ind AS, which has been introduced by Ministry of Corporate Affairs on 13th August 2025. On the date of 13th August, MCA has issued amendment in Ind AS. Now that includes two very important amendments. One with respect to current non-current liability of a long-term loan, and second very important thing is about supply finance arrangement. In this video, I am going to discuss about the current non-current aspects in case of a non-current liability and how it is being modified. Let us begin. Para 69 of Ind AS 1, which provides you the criteria when an entity shall classify a liability as current. So it talks about the few criteria wherein if it is fulfilled, then only it is a current liability. Where the D para says that it does not have unconditional right at the end of reporting period to defer settlement of liability for at least 12 months after reporting period. So parity was mentioning the word that if the entity does not have unconditional right to defer, so if there's no right to defer, unconditional, not no unconditional right to defer for more than 12 months, then only it will be classified as a current liability. The change which is that the unconditional word, if you just look at it, has been deleted. The word unconditional is deleted. It means that there is no need to have unconditional. Now this was in practice difficult to comply with it. Wherever the loan has been arranged between the bank and the borrower, the agreement is signed, and agreement has so many criteria which are mentioned, where it's difficult to say that a borrower has unconditional right to defer. It is always mutually done. There are few conditions which are part of this particular agreement. However, there is no unconditional right. Borrower cannot dictate by itself saying that yes, I am not going to pay within 12 months. It is subject to some mutual concept. So what unconditional was not actually correct, technically correct. That's why that is been removed. Second very important thing is that these terms of the liability that could at the option of counterparty result in by issue of equity instruments do not affect classification. Now that line is also removed. In the next line, I'm going to discuss about what is the impact of this particular point. Now let us now understand the right to defer settlement. So on one way, what is done? They removed unconditional because practically it is difficult to say that a borrower has unconditional right to defer. Second, para 72A, which has been added, which may prescribe that right to defer settlement of liability for at least 12 months after reporting date, it must have substance. So they look at more on the substance principle rather than legal form, and the right to differ should be looked into from substance point of view, not only merely what is written in the agreement. So unconditional right has been removed on one side. Second very important thing is that they talk about substance rather than the complete legal form. But that particular substance must exist at the end of reporting period. So for 31st March 2026, when talking about as on 31st March 2026, the in substance the right should exist with the borrower to defer settlement for more than 12 months to continue to classify as a non-current liability. So this is the first very important change as far as the unconditional and right to defer is concerned. Let us look at one very important change, that is on covenant testing. The word covenant is the conditions. There are a lot of conditions which are attached to any agreement. Now that conditions sometimes which are not compliant with it, there's a breach of covenant. If there's a breach of covenant, generally the loan agreement gives a right to the lender that they can insist to borrower for making immediate payment. So loan agreement has a terms conditions, and there are a lot of conditions which prescribes the borrower to do something like maintaining a ratio, infusion of fund by the directors, then providing quarterly statement, monthly statement. So there are a lot of covenants or conditions which are prescribed as a part of the agreement. If there's a breach of agreement, and if you just look at the earlier paragraph, if there's a breach of agreement, then there is a probability that it can be classified as a current liability. So now, what is mean that in case of covenant, if it is a breach on or before reporting date, generally it is a current because covenant is a breach. So by law, by legal agreement signed, which is a part of the covenant, lender can ask to make immediate payment. However, if that breach is waived before the reporting date, no option because there's a breach of covenant on 30th March. Before 31st March, the breach was waived by the lender. So on 31st March or reporting date, that is only waived. As of reporting date, it will be still classified as non-current. However, if the waiver is obtained after a reporting date, so till the time the position was such where if the waiver is obtained after reporting date but before financial statements approved for issue, in that case it will can be still classified as a non-current liability, which is a part of Ind AS carve out. However, now this Ind AS amendment made it very clear that now onward in the future, from 1st April 2026 onwards, the Ind AS carve out will no longer be there. So the waiver of breach should be obtained as on the reporting date. If it is obtained after reporting date before financial authority approval, in that case, it won't be classified as non-current. It will be converted to current liability. So that is from next year. For the financial year 2025-26, when you just look at, if the waiver is obtained on or before reporting date, for both year non-current. For 25-26, if it is after reporting date but before approval, it will still be non-current. But from 1st April 26, this Ind AS carve out has been removed. So in case if the waiver is obtained after reporting date, then it will be a non-current. No, it will be current. It will not be a non-current. It will be current because as on the reporting date, the waiver is not obtained. Let us take for example, loan with DSCR covenant tested annually. As of 31st March, DSCR is below required limited. Waiver obtained in April before approval of financials. So, in general case, today as we exist, today the Indians exist, and for up to 25-26, if waiver is obtained before approval of authorization, then it will still be classified as a non-current because of India's carve out. However, from next year onwards, it will be treated as a current, and they also remove a minor versus major kind of covenant from these particular provisions. So, from 1st April 2026 onwards, Ind AS carve out are being removed. Now it is aligned with IFRS, and that's why I want us to be very very careful as far as the covenants are concerned, because they talk about the breach waiver as on the reporting date for continuing to classify for non-current. Now a point which I referred to in the first slide, where there is a deletion of the case where in case of settlement happens through the equity instruments. Now in such case where the settlement term of liability said at the option of counterparty. So if the company has issued the instruments and the holder of the instrument has option to settle by way of the equity instrument of company, in that case it says that you would look at the option given to the holder. Can the holder of the option is able to do it has a right to exercise the option within next 12 months? If it is yes, then it will be a current as far as liability is concerned. So if it is presented as a part of equity, if it is presented as a part of equity instrument, then there is no need to worry about current non-current liability. However, it has been presented as a liability part, then it says that if if the holder can trigger settlement within 12 months, then that debt will be classified as current. So this is the story as far as the current and non-current for the liability and equity part is concerned. For equity, you don't have to worry. Liability, it is the current if the holder has right to exercise option within 12 months from the reporting date. So very small video was there, and now I'm just giving you a brief key takeaways of this. First thing is that the right to defer settlement, the word unconditional removed, which is a good practical movement. Second, very important thing that it is substantive. So we need to have to look at the only legal form. In substance, the borrower has a right to defer. That is what is to look after. Second very important thing is the covenant testing, whether any condition which is breached and waiver of that particular condition which is breached is obtained as on which date. So now it is aligned with the IFRS from 1st April 2026 onwards, where there is no Ind AS carve out, and you have to ensure that the waiver is obtained as on the reporting date. Disclosures are increased for future code compliances. So practically, when you just look at the impact on companies and professionals, the most important thing you need to look at the loan agreements. The loan agreement may have lot of covenants which may not be very critical, very important, because there's no distinction of material and minor covenants. So just look at the loan agreements, any covenants which you feel are not required, it has been written to that. And but it gives right to the lender to call for the immediate, that you may have to revise the agreements, look at the covenant schedule. As far as finance and account team is concerned, they need to ensure compliance of the covenants, and in case of any non-compliances, they must obtain the waiver from the lender before the reporting date is concerned. So the tighter monitoring and reporting will be expected. So with this, friends, these are the few important amendments. Next, I'm also going to discuss about supply finance arrangement. If you have any questions, any query, please feel free to write down in a chat box, or you can reach to me. Thank you very much.